Alright, dispute resolution procedures. Engineer Certification Reference Guide, Federal Railroad Administration, revised August 2000. Dispute resolution procedures. Alright, dispute resolution procedures. If denied recertification or certification revoked, a person may petition for the FRA to review the railroad decision. FRA delegated initial responsibility to Locomotive Engineering Review Board. Locomotive Engineering Review Board composed of 3 FRA employees selected by the administration. Any person has been denied certification, denied review certification, has a certificate revoked, will leave the railroad incorrectly determined and fail to meet the requirements of the regulation making the decision to deny or revoke certification may petition the FRA administrator to review the railroad decision. FRA administrator delegated initial responsibility for the adjunction such disputes for the Locomotive Engineer Review Board. Locomotive Engineering Review Board should compose at least 3 employees of the FRA selected by the administrator further delegated to selection. Responsible for the director, office of safety and enforcement. Administrator shall be delegated with the chief counsel authority to appoint for him staff of the senior counsel for the Locomotive Engineering Review Board. Trial attorney Alan Nagler, present services in this capacity. Locomotive Engineering Review Board created with FRA ordered 1118 dated April 17, 1992. Currently consists of the chairman, John McGarry, regional administrator, Hearst, Jim Elroy, operational inspector for Kansas City, and Ken Boynton, operation OP inspector for Riverside. Alright, Locomotive Engineering Review Board. Purpose of the Locomotive Engineering Review Board review petitions of the railroad has opportunity to respond with petition assertion render decision based solely on the record presented to the Locomotive Engineering Review Board. Locomotive Engineering Review Board must consider the incident as a certificate and issue railroad rules and policy evidence of conform railroad decision procedural requirements. Purpose of the Locomotive Engineering Review Board is to review submitted petitions after providing railroad opportunity to respond with the petition assertion review of the record, not a hearing. In preamble of the interim final rule, page 1901, FRA response request clarification. FRA review process based on written record of FRA still and staff analyze railroad decision, make recommendation. Locomotive Engineering Review Board will determine whether the denial of revocation proper under this regulation. In reviewing each petition, the board is responsible for considering the factual procedural of the 240-307. The dispute of the actual disputes could involve the question whether the information relied on the board was correct. If the person did not pass knowledge or operated the train within prescribed limit, the speed limit. Factual disputes could also involve whether the certain and equitable consideration warrant reversal of railroad decisions on the grounds of the due to certain peculiar underlying facts. The fact of the decision would produce an unjust result and unintended by the FRA rules. The board will consider assertion of the person failed to operate the train with a prescribed speed limit because of the defective equipment. Considering factual assertion, Locomotive Engineering Review Board used substantial evidence standard and considered procedural assertions of the Locomotive Engineering Review Board used substantial harm standard. Locomotive Engineering Review Board approval of review petition. The railroad has opportunity to respond to petition assertion rendered decision based solely on the record presented with the Locomotive Engineering Review Board. Locomotive Engineering Review Board considered the incident of the certificate issue railroad rule policy evidence to conform railroad decision procedural requirements. Finally, the board will consider the procedural disputes involved with the question whether the process followed by the railroad, such as the correct adherence to the limit prescribed with the FRA rule and governing an agreement with appropriate and fair. Considering factual issues, the board will determine whether the substantial evidence support of the railroad decisions and negative findings for the grounds of the reversal. Considering procedural issue of the board standards of the review will be determined whether the substantial harm was caused for the petitioner by virtue of the failure to adhere to the dictated the procedure of the making the railroad decision and finding substantial harms of the ground reversing a railroad decision. At legal issues involved with the interpretation relation statute of the administrative FRA board will provide the de novo the review, which means that the board will not bound legal interpretation reached by the railroad making its decision. Decision-making power of the board is limited to proof of the railroad decision. Overturning railroad decisions, return in this case to the railroad additional fact-finding. The board will not be empowered to make determinations concerning qualification under this regulation. Consequences, if any of those of the determinants must be revolved under the dispute resolution mechanism and not directly involved with the FRA. For example, the FRA cannot order railroad to alter its senior roster to make an award back pay to accommodate finding of the railroad wrongfully denied certificate. In reviewing petition, the FRA rules to assure the qualification, determination, performed, and compliance with the rules of taking appropriate remedial action to detect non-compliance. All board decisions are provided in both written or writing, both the petitioner and the relevant railroad. Any explanation of the board's finding, the board decision subject to appeal with adversely effective the party. The Locomotive Engineering Review Board reports quarterly the Associated Administrative Safety on the action taken as proceedings pending before the board. To the date of November 9th, 2000, Locomotive Engineering Review has received 757 additional. Of those, 637 have been closed, 36 are open, and 33 withdrawn, and 15 are pending. The FRA has dismissed 2.77% and has granted 43.44 overturned railroad decisions. It's denied 53.79 of the petitions as of November 9, 2000. Yearly petition submissions. Petition decertification costs. Major railroad petition percentages. Average petition completion times. 4 levels of appeal. Locomotive Engineering Review Board administered the hearing conducted with the presiding officer appeal of the FRA Administrative Judicial Review. Locomotive Engineering Review Board is only the first level of appeal. The actual 4 levels of appeal. Locomotive Engineering Review Board administered the hearing appeal of the Administrative Judicial Review to the Federal Appeal Court over the FRA final agency action with a denied recertification revocation based on Section 706 of the Administrative Procedure. The court would need to decide whether the FRA administrative decision was arbitrary, capricious, abuse of discretionary, otherwise not in accordance with the law. Petition requirements be in writing 3 copies of the FRA docket clerk with supporting information, petitioner full name, current mailing address, daytime phone number, address, and railroad acts, location, date, identities, full person present, and the individual railroad's actions. Who obtained with the railroad decision with a denied certification, denied recertification, revoked certification, person shall file with the petition review with the comply with 240-403. Each petition shall be in writing, be submitted duplicated with a duplicate clerk. Office of the Chief of the Council, FRA, 1120 Vermont Avenue, Northwest, Washington, D.C., 20590. Contain available information for the person thinks of the person believed of the Railroad Act and properly including the petition full name, correct current mail address, daytime telephone number, name, and address of the railroad. The facts of the petition believed the constitute within proper action for the railroad, specifying location, dates identified with the person who present involved with the railroad action, the degree known by the petitioner. Petition requirements explain the nature of the remedial action sought will include copy of all of the written documents filed with the time or manner within 6 months after the date of the railroad denial or 4 months after the revocation decision. Filing period of the revocation may be extended with the Locomotive Engineering Review and caution. 4. Explain the nature of remedial action sought to be supplemented with all written documents of the petition or possession of the document of the railroad decision. Be filed with a timely manner. Petition seek the review of the railroad decision, revoke or deny or certification filed with the FRA more than 6 months after the date of the railroad denial revocation decision, whether be denied as untimely. A petition seeking review of the railroad decision, denied certification, recertification filed with the FRA more than 100 days after the date of the railroad denial decision will be denied as untimely. Petition seeking a review of the railroad decision revoked the certification according to procedure required in 24307 filed with the FRA more than 120 days after the railroad revocation decision denied untimely except for the Locomotive Engineering Review Board shown with the extent of the petition filing period any time with the discretion provided with the request for the extensions filed before the expiration period provided in paragraph or 2 provided with the failure to timely file with the result of the excusable neglect party aggravated by the board decision to any petition is untimely may file an appeal for the administrator in accordance with the 244.01. Her process qualification review petitioners acknowledgement of the writing provide copies of the petition railroad 60 days to submit with the FRA Office of Safety prepares copies of summary refer to Locomotive Engineering Review Board for decision grant with a denied decision written in petition with the railroad. Each petition shall be acknowledged written with the FRA contained with a sign with the docket number of the chain of the FRA and 10 with the render of the decision within 6 months upon when the FRA will notify the railroad has received the petition provided with the railroad copy with the petition. Railroad will be given the period of the 60 days to submit with the FRA information. Railroad counsel pertaining with the petition. Late filings will be considered with the extent with the practical railroad submit with the information. One identify with the petition name with the docket number to provide with a copy of the information being submitted for the FRA to the petition, submitted with the info to triplicate with the docket clerk FRA. Each petition then be referred to the Locomotive Engineering Review Board decision. The board will determine with the denial, revocation, recertification, proper use of the correct regulation based on incorrect determination of the person failed to meet qualification requirements for the regulation grant and denial of the decision. Accordingly, the board will not otherwise consider property of the railroad decision will not consider whether the railroad properly applied and more stringent requirements Notice the decision provided with a written both of the petitioner and railroad. The decision will include the facts of the finding, which is based on 240-405. Request for administrative hearing and adversely effective with the Locomotive Engineer Review Board decision. Petitioner of the railroad has the right of 204-0409. Following written request within 20 days, the Locomotive Engineer Review Board name, address, and telephone number of representative of actual issue signature of FRA will arrange the presiding officer for the adversely effective with the Locomotive Engineering Review Board decision. Either the petitioner or both the board of railroad involved shall have the right to administrative procedures prescribed in the 24409. Next, have the right adversely effective party shown within 20 days to serve with the board decision on the third party file with a written request of the docket clerk, DOT, Central Docket Management System, and asked if the building 7th Street, Southwest, Washington, D.C. 20590, with the result of the failure request for the hearing of the period provided with the Locomotive Engineering Review Board constitute final agency action. Parties elect for the request for the hearing person shall submit with a written request of the docket clerk with the following: the name and address for the telephone number of the respondent requesting person, designated representative, if any specific factual issues in industry regulation laws of the requesting parties allegedly need to be examined in connection with the certificate decision. In question 3, the signature of the requesting party with the requesting party representative, if any upon request for the hearing request comply with above. FRA arranges the appointment of the presiding officer, Joe King, who with the schedule for the hearing with the earliest practical date. Administrative hearing 24409, conduct the presiding officer dean over the hearing of the finding of fact for the determined correct application must authorize discovery and impose with a non-monetary sanction willful failure or refusal to comply with the discovery request. Administrative hearing with the engineering qualification petition for the docket of the presiding officer who can be hearing. Person authorized by administrative, including administrative laws of the presiding officer, may exercise the power of the administrative to regulate with the conduct of the hearing with the purpose of achieving the determination of all material issues of the controversy. The presiding officer shall convey with the preside over the hearing, and the hearing shall be deemed over the hearing with the relevant fact for the determine the correct application. Part 240 for the facts of the presiding officer determine there is no genuine issue covering the sum of all the material facts, limiting evidentiary proceedings to the issue of the material fact of which with the genuine dispute the presiding officer may authorize discover the types of the quantities within the presiding officer's discretion contribute. Fair hearing without unduly burdening over the party. Presiding officer may impose the appropriate non-monetary sanctions, including limitation, representation, or evidence of the issue with any all parties willful failure, refusal to comply with the proof that discovered the request. Administer the hearing 24409. All petition, motion, and response must be signed. All documents filed and served must be served upon all parties. Over the petition with the motion with the response not otherwise required with the document should be signed by party filing the same and or by duly authorized representative of the record by any other person if the signed by such other person. The reason therefore may be the day with the power of the attorney other authority authorizing such of the person who subscribed to the document must be filed with the document with the signature of the person subscribing the name of the document constitute with the certification has read the document for the best of the knowledge, information, belief that every statement contained in the document is true, that no such statement is misleading, and that is not interposed for the delay with to be vexatious. After the request of the hearing is filed with all the documents filed, served with one party must be served upon all parties. Each party may with a designated person upon whom the service is to be made, not specified by law, regulation, directed with the presiding officer. If the party does not designate a person upon whom the service is to be made, the service may be made upon the person have this prescribed with the submission of the party being served unless otherwise specified by the law, regulation, directive of the presiding officer. The approved service shall accompany all the documents for the tender or filing. Ministry of the hearing may strike the dismissed documents may hear from the person or the representative may have an attorney to be examined. They may request the consolidated separated hearings of two or more petition request extended action periods. Who adopted the initiating field of the terms of the proceeding that's not of the substantial compliance with the applicable law, regulation, directive of the presiding officer may strike with the dismissal of the parts of the document requirement to amend with any of the parts of the proceeding with the may appear with the be heard with the person with the authorized representative with any person testifying here with the deposition may be accompanied with the representative advised by the attorney of the representative that may be examined by this person any part, but the may request the consolidated separate of the hearing with the two or more petition motion for the presiding officer for the may arrive at the same similar effect for the matters for any of the reasons deemed the more efficiently held together. Simply provided in 240-407C on the failure to timely request the hearing in the 240-409U4. Witnesses and constitute final agency action unless they agree with the parties of the appeal for 30 days after the issuance, whenever the party for the right is required to take action in with a prescribed period prescribed by this part by law, regulation, directive of the presiding officer. The presiding officer may extend the term for the period without notice for good call, but provided that another party is not substantially prejudiced by such extension, and at the request extending of the period when it's already expired, but may be denied and it's untimely. Minister of the hearing 24409 filing motion witness testimony given under oath of recorded verbatim and any application for for the presiding officer order of the rule not otherwise specifically provided with its part shall be in motion, shall be filed with the presiding officer written served upon all of the parties' motion unless for the during of the hearing shall be written with the motions during the hearing with the made orally on the record with except for the presiding officer made direct for the oral motion be reduced for the writing. Any motion state with the particular grounds therefore the relief of the order sought with it shall be accompanied with the affidavit the other evidence desired to rely upon so for the not already of the record any matter submitted into the response of the written motion must be filed and served within 14 days of the motion without such evidence directed by the presiding officer. The testimony of the witness of the hearing shall be given and under the oath of the hearing shall be recorded with the impediment the presiding officer shall with the party of the proceeding adequate operation during the course of the hearing of the presentation argument with the support some with the opposition of the motion objection exemption for the ruling with the presiding officer may permit the oral argument issued for the presiding officer deems of the appropriate with the beneficial evidence for the augmentated evidence for the pre-affirmed offered orally shall be transcribed period with the part of the record and physical evidence or written argument received with the preferred to show be made with the record with the exempt of the presiding officer may authorize substitution copy photograph the description deemed appropriate. Federal rules evidence U.S. Court Magistrate for the Presiding Officer for the Administrator oath to the issue subpoenas adopt written evidence procedure for the examine the witness regulate with the course of the hearing. Presiding Officer shall employ with federal rule the evidence United States courts and magistrates general guidelines for the introduction of evidence notwithstanding with the previous paragraph and with the relevant and probative evidence shall be received unless presiding officer determines the evidence is unduly repetitive so the extent of the lacking the relevance of the mission that admission would impair the properly order of the fair resolution of proceeding. Proceedings officer may administrative oaths of first and issue subpoenas provided with the 209 7 to adopt indemnity of the procedure submission evidence for the written form examine the witness over the hearing convey recess adjourn otherwise regulate with the course of the hearing and 6 take any other action authorized consider the provision of the part permitted by the law and they expedite with the hearing aid with the disposition of the proceeding. Administrative hearing 240-409 petition of the railroad FRA shall be the party for the hearing may be to testify conduct the cross-examination. The hearing of the petitioner have the burden of providing case proving its case by the preponderance of the evidence. FRA's mandatory party for the job of the hearing is the respondent. The petitioner of the locomotive engineer review board involved with the taking of the certification of the FRA shall party for the hearing. All parties participate for the hearing and may appear for the be heard on their own behalf of the real of the designated representative of all parties may offer relevant evidence, including testimony to conduct the cross-examination. Witness may require to be recorded with the relevant facts. The party requesting administrative hearing shall be for the hearing petition for the hearing petitioner shall have the burden proof against the preponderance of the evidence having hence for the hearing petitioner of the railroad involved taking certification action that the railroad was providing per burden of proof that the decision to deny certification deny recertification revoke certification was correct. First lay for the position before the locomotive engineer review board hearing petition for the person was burden proving the railroad decision to the deny certification deny recertification revoke certification was incorrect. Between the petitioner and locomotive engineer review board, the railroad involved with the taking the certificate action party who with the hearing of the petition will be respondent. FRA will the mandatory part of the administrative hearing after the start of the trust proceeding with the FRA will be respondent. Alright, administrative the hearing 24409 written decision closed record find all the factual conclusions served on all the parties not final for 30 days after the issuance constitute with the final agency unless they agree with the parties of the files a plea within 35 days of the issuance does not see precedence. Alright, the record proceeding shall conclude with the conclusion of evidentiary hearing to the presiding officer allow additional time of the submission of additional evidence instead of the record shall be left open until for the time of the presiding officer grants for the purpose of the close of the record the presiding officer shall prepare of the written decision for the proceeding. The decision shall contain the final fact conclusion for the law as well for the basis of each of the concerning all the materials issued for the factor of the law presented with the record shall be determined for the hearing of the petition. All of the parties for the proceeding shall not become final for 30 days after the issuance. Constitute final agencies unless all of the aggrieved parties file an appeal within 30 days after the issuance is not presidential. Appeals. Aggrieved party may file with appeal within 35 days, may file with a reply to an appeal within 25 days. Administrative, the extent of the period of the administrator have sole discretion, permit oral argument on the appeal. Administrative may remand, vacate, affirm, reverse, alter, and modify the decision. Any party who agrees with the presiding officer decision with the may file an appeal. The appeal may be filed within 35 days of the issue of the decision. The FRA, DC, copy of the appeal with shall be served on each part of the appeal should be set forth. The objection presiding with the officer's decision supported reference with the applicable law regulation with a specific reference to record. A party may file with the appeal to appeal 25 days if the serve of the appeal with the rights to the support with the reference applicable law regulation specific reference with the record party with the realizing evidence contained in the record. Administrative administrator makes shown with the period of the filing an appeal with the response of good cause shown with the provide with a written request for the extension served by the expiration applicable period provided within the section. Associate administrator sole discretion permit oral argument on the appeal for the owner's own initiative with a written motion. Any of the party of the administrator may grant the party for the opportunity for the oral argument. Administrator may remain, vacate, affirm, reverse, alter, or modify the decision of the presiding officer administrator. Continued decision constitutes final agency except for the terms of the administrative decision. For example, the remaining of the case of the presiding officer shall be the party of the administrative remedies will be exhausted. When the parties appeal with the local and engineer review board decision pursuant with the 240-403E with the administrative may affirm with the vacate the board of the decision remain with the position of the board firm with the proceed with the administrative decision firm with the board with the decision constitutes final agency action. No, a remand tool is which allow the applicant appealated decision maker to send the case back with the tribunal body with which of appeal for the further deliberation. No other authority to vacate that may be necessary with the administrative wish if the null set aside with the entire record of the judgment, second and term final rule, effective November 13, 1995, and added two new definitions for administrator and filing 247. Administrator means administrator of the FRA, deputy administrator of the FRA, the delegate, either the filling of the means for the duplicate document filled under this part shown with the defined deemed filled upon the receipt of the document Cert 247. Alright, record keeping identification qualified person record of relevant data is data of the joint operation certificate railroad oversight report.